with this, the present topic is the faceless assessment. I will take a few minutes before discussion on the topic, and if any important topic is not there, that I can switch over because time will not permit. Friends, before going for the discussion in detail, I'll just give you an overview what is the status at present. I have taken the statistics for the financial year 2018-19, which is already displayed in the website of the Income Tax Department. We are at the end of 2019, the total population in India is around 136 crores. Out of that, total taxpayer is only 6 crores 73 lakhs persons filed the return, not taxpayers, they filed the return. Only 6.73 crores return has been filed for the financial year 2018-19. Out of that, individuals, those who are actually not contributing more, is only 6.32 crores. You see how much remains. The 9 lakhs is the company, farm are 14 lakhs, HUF are 12 lakhs, association person are again 10 lakhs, trust are only 2 lakhs, and the rest of the other assets. Friends, why I am giving this, before going for what is the intent of the government to go for the faceless assessment, that will give you an overview. Friends, you please see the growth rate of direct taxes is increasing. It is last year 13.54%. Previous year 2017-18 it was 17.93%. And total tax collection was 11.36 lakhs crores. Friends, when the face assessment was introduced, prior to that, only 0.35% of the returns were processed. Individual return hardly processed. Assessed. Almost all return processed. I will give an overview what is the processed. So assessment is very negligible, and government could not in a position to collect the revenue because of the suppression of the incomes. Friends, if you go to another aspect, you will find 30,000 companies during demonetization deposited 70 billion rupees in 6,000 bank accounts, which the department already captured going for the assessment. And 150,000 taxpayers, individual taxpayers, those who are paying tax more than 1 crore. This is the overview of the statistics. And government always wanted to capture the tax base so that more tax collection will be increased, because the indirect tax collection is reducing, the proportionate direct tax is increasing. With this background, I will switch over to the discussion of the topics. Friends, you will see what is meaning of assessment. It is nothing but it is verification of the return you filed. Assessee individual 6.373 crores persons, I will tell persons, filed the return, and that return 100% processed, means whatever e-return you are filing, that is processed under section 143(1), and whatever return physically filed, wherever permissible, that has been also digitized. That means that is uploaded by the department in the portal, then it is also processed under 143(1). Most of the returns were processed. It is known as summary assessment without calling the assessee. Okay. And assessee filing the return on these sections. In the normal return is 139(1), return of loss 139(3). Belated return means the return which you are not filing within the date, but you are filing by 31st March, that is under 139(4). And 139(5) is the revised return which you are filing. Directions given by the AO during the assessment, because notice is very important. Without notice any assessment taken place, that is not an assessment, it is null and void. So 142 notice which is issued directing the assessee to file the return, that is the return is filed. Reassessment cases, 148 notice has been issued, and you are required to file the return, or you can tell that the previous return is my return, which you can take for the assessment. 153 is the block assessment, it is known as search and seizure, which has been taken place, and assessee has been asked to issue the notice to file the return. This return has been taken by the assessing officer for assessment. These are the sections. self-assessment is not an assessment. You yourself is computing your income, paying the tax after taking all the deductions. 143.1 is a summary assessment without calling the assessee. Almost all return has been processed in the income tax portal by the CPC. And one thing, remember, the CPC officers do not have the power earlier in 2008, but after that, under certain circumstances, they can rectify the return. They can ask you, they can issue the notice, point out these are the differences, these are the needs to be rectified. And without giving notice, the process cannot be completed. That's why under section 139(9), they always send back your return in the emails to tell that you find out, you revise your return. So either you have to revise or they have certain powers. If they are finding any discrepancy, they have to do, because this is happening after 2008 amendments. 144 is the best judgment assessment, where the assessee could not file the return, or file the return, could not respond to the notice of the department, could not submit the documents, books of accounts. The assessing officer can go for best judgment assessment after taking the permission, but recording the facts under what circumstances he is going for the best judgment assessment. So it is my humble request all of you to at least respond, otherwise you will be in the loss. 143 is the real assessment, which is known as scrutiny assessment. There are two types of scrutiny. One is the limited scrutiny and one is the total scrutiny. Limited scrutiny means a particular items will be only under notice, it will be sent to you, and which you have to verify, and you have to respond to that. And as already I told you, 0.35% of the return is only processed under 143.3. And a reassessment is when the assessing officer has to reason to believe that there is a escape into assessment, means the expenditure you have overstated, the income you have not taken into account, wrong claim is made, but assessment completed, assessing officer has not seen it, so they can issue the notice under 148, and they are asked to file the return. You are required to file the return, and if you do not want to file the return, you tell that my original return is the return, which you can take for as a reassessment. So reassessment has to be taken place. Reassessment always 147/143.3. So whatever original assessment completed, it will be become null and void, and the reassessment will be taken for further proceeding. You can go for appeal, etc. And 153A and C are the block assessment. 153 is the search seizure case, the assessee. The assessment will be taken place under 143A. But if during the search and seizure any third person is coming to the picture, then it will come under 153C. So these are the assessment. I will not go into discussion in detail all the items. So rather I will go for the topic of the discussion. Friends, you will find nowadays almost all assessments has been taken place in the e-assessment system, present e-assessment system. 2006, the department first time digitally filed the return under TDS. 2009 is the income tax return. Then 2015, the project has been taken up for the purpose of assessment. Only 5 projects was taken up. Then subsequently assessment has been taken up, and most of the assessment under 143 has been taken place on the e-filing system, e-portals. So your income tax business application software, which has been developed, integrated with the e-filing system of the department, where all the correspondence has to be made by the department, and you have to respond only through that portal. So and that is known as e-proceedings actually. And the e-assessment has to be taken place through the e-proceeding. E-proceeding meaning is it is an electronic platform which is a part of the portal of the e-filing account of your, means assessee, and it is a part, functionality, one of the functionality of the ITBA. So nowadays the department is issuing the notices, all communications through your email with the SMS, and through your registered address. Either it is in the email available in the your ITR return, or email available if not in the ITR return, the other whatever email or telephone numbers are there. Otherwise, it is the company's register of company's registration. So that number they are using. So these notices has to be sent only through the portal, and you have to respond through the portal. The difference is because these things are going on up to 2019 September 12th. So that means practically 2017-18 assessment has been taken place through e-assessment system under the old system. I will not discuss more on this, so because of the time constraints. And these are the sequential e-assessment system. 2015, the 5 projects has been taken place. Then 2015, the rules has been amended to make it convenient for the going for the assessment in the e-assessment system. 2016-17 procedure standards has been given what procedure to be followed by the assessing officers. Similarly, income tax business application only came into effect from 2017 because it is not practically possible to make the e-assessment without the ITBA software and with all the functionality. So budget 2018 amendment has been taken place. 3 sections has been amended. 143, 3A, 3B and 3C has been amended. What is the amendment has been taken place? Now it authorized the central government to notify a scheme for the e-assessment system, which was notified by virtue of notification 62 and 61 from the 12th September 2019. So which is the present subject matter of e-assessment or faceless assessment. And there are a number of instructions also issued from time to time how to go for the assessment. It is an instruction given to the departmental officers what procedure to follow during the e-assessment system. So friends, with this, let us also go for the how the e-assessment has been taken place. I am only speaking to the e-assessment scheme 2019, which was notified in the 12th September by virtue of notification 61. And department also issued another notification, notification number 62 in the same date, clarifying the procedures to be followed by the departmental officers during the e-assessment system to be taken place by following the e-proceeding system in the ITBA functionality. And this ITBA functionality, we have to log on to our own account in the e-filing system. So everything will be through the e-filing system. And friends, many of you may not be have the habituated of using the e-portals, and you will find around 25 to 30 e-proceeding steps has been given, which in the yesterday on insight to assessment, and including e-assessment, one booklet was anyhow I written this book and it was published by the Institute Tax Research Department, when one chapter is there consists of 60 pages where the step by step how to go for each proceeding has been given. Friends, after this notification, department has not issued any standard operating procedure for the e-proceedings. These e-proceedings are existence as on today, and which is utilized for the responding to the department, and department is also responding to you in the same portal. All the details are available there. Friends, we will see in the e-assessment scheme, which was notified in 2009, we will find there is a National E-Assessment Center, and which is the nodal agency. Actually, we can see the apex body, and under which there are 8 regional e-assessment centers are there. Practically, regional e-assessment centers don't have any function. Under them, 4 units are there. These units are your regional, under the regional e-assessment center, 4 units are there. That is assessment unit, verification unit, technical unit, and review unit. The 4 units are there. The difference of the faceless assessment is under the prior to 12th September 2019, the assessment e-proceeding which was followed, it was with the jurisdictional assessing officer in your jurisdiction. So practically I am telling, when e-filing system in existence, even also departmental people will ask you, please provide us a written copy physically, please provide us a tax audit report physically, please non-official come us to explain what is the what. It is happening, but practical there is an instruction that don't call the assessee unless there is a requirement. So, but practically we are going to submit all the physical returns, physical copies, physical proof of my tax holiday benefits, deductions, etc., and continue with the assessment. But in the faceless assessment, it is not going to happen because the assessment is not going to take place by the jurisdictional assessing officer. They are doing only the postmortem work. We can say, will you discuss something? But actually the assessment will be taken by these units and through the e-assessment center. And this is the constitution. Actually, these are the organization chart displayed by the department. These are manned by the department. Total 2,686 officers already appointed. The post has been sanctioned. So these are the, with this background, let us also, I'll take 15 minutes to explain how the process will be taken place. Friends, what is the function of these units? Because this, first you have to understand it. The National E-Assessment Center is the apex body. All the 4 units and National E-Assessment Center, all correspondence, cross correspondence will be only between them. Regional assessment center has no role to play. And the assessment unit will facilitate the conduct of assessment, seeking the information and analyze all the information and complete the assessment. Now the function of verification unit is, whenever the assessment unit require any help for verification, they have to make inquiry, they have to go for cross verification, they have to examine the books of accounts, they have to examine of witness, recording of the statements, etc. will be function of the verification unit. Technical unit will give the advice on legal, accounting, forensic, information technology, valuation, transfer pricing, data analysis and management. And your review unit is very important. Why I am telling, they will review the draft assessment order. We will discuss the process subsequently, but keep in mind what is the function of these assessment units. They will check whether the relevant material fact has been taken into consideration in the assessment or not, whether the issue on which addition disallowance made should be made have been discussed in the draft assessment order. You will find in many cases at present, assessing officer is showing the back. What is the disallowance made in the last year? Okay, same disallowance will continue. Even if I am getting the relief in my different judicial authorities, it is in my favor, but department is not looking after that. But here something different, they have to see whether the fact has been discussed or not, whether the applicable judicial decisions has been considered or not. That is very important. Nowadays it is not happening. Even also e-assessment system I am talking. Again, assessee, we are going further appeals. Checking arithmetical correctness, modification if required, and such other function as may be required. So these are the functions, and you will find this, and the very important point is assessment unit while going for the assessment. So what is the procedure they have to follow for the assessment under this particular section? Actually, I have forgotten, nobody is pointing out. This is the process has to be followed. What will happen? Any assessment will be taken place. I am giving one brief. After this notification 61 has been issued from 12 September 2019, department identified 400 cases and notice has been sent to them to cover the e-assessment under the new scheme. 4 lakhs assessee only, out of which 10,000 notice has been returned because the address is not available. Okay. So first is department, there is a lot of criteria has been decided on what basis you will go for the assessment. As I told you, the first e-assessment system is only applicable to section 143.3. They are not going to make any assessment for 147, 148 reassessment. Base judgment assessment, block assessment is out of the purview of the e-assessment. But I think after 3-4 years, you will find all assessment will take place there, including the individuals where no assessment is taking place. 6 crores assessment is not taking place. That is going to be regularized just by return maybe within 5 years. So we should be very careful on that. The first point is they decided 100 criteria. They notified internally. Some of the increase in share capital, reduction in share capital, increase in loan during the year, repayment of the loan during the year, foreign assets, income not shown, diversification of income, more cash transaction, like this. This is not a forum to discuss because more 100 items has been decided, and that 100 items, if anybody is following, they will be subject matter of assessment under 143.3. Under this particular provision, what will happen? The notice has to be issued by the National E-Assessment Center under section 143.2. Friends, you remember, any assessment taken place without issue of the notice is null and void, even if it is gravity is there or there is a genuine case is there. But assessment has to be made by way of issue of the notice, 143.2. So when notice has been issued, this notice will be issued by only National E-Assessment Center. Then the response will be submitted by the assessee within 15 days to the National E-Assessment Center. After receiving the response, immediately the National E-Assessment Center will alert one of the assessment unit of any of the region, Madhuvada, 8 regions are there. And it will be done through the automated computerized selection system. So nobody knows where it will go, and the officer who is in the National E-Assessment Center has no role to play. Simply automated, it will go to any of the centers. So one of the regional assessment center. After receipt of the intimation regarding going for the assessment by the assessment unit, they will verify they require any information. So immediately they will write to the National E-Assessment Center that these are the informations we require. Friends, again I am telling, there is no connection between 4 units each other. There is no connection through the E-Assessment Center regional. Only all has to be made through the National E-Assessment Center. So when the assessment unit will intimate to the National E-Assessment Center that these are the informations I required for the assessment, in that case, National E-Assessment Center immediately will issue the notice for submission to the assessee for submission of the information, and after that it will be forwarded to the assessment center. And friends, what will happen? Assessment center, after taking into account all the information, shall make a draft assessment order. Actually, draft assessment order, this is a new concept. It was earlier in the under section 144C, I think, it was applicable to the non-residents, where the draft assessment will be completed, then it has to be sent. But this is a draft assessment will be made by the assessment unit. And this the draft assessment will be again sent to the National E-Assessment Center. National E-Assessment Center, after examining the order, may decide. There are 2 options. First is finalize the assessment as per the draft assessment order and serve the copy of such order and notice for initiating penalty. You remember one thing, when the assessment is completed, the assessing officer not only completed the assessment determining what is the profit or loss, what is the tax payable after adjustment of the advance tax or whatever self-assessment tax, but also they have to, any initiation of a penalty, they have to mention in that assessment order under chapter 12, I think, it has to be taken, sorry, 22, it has to be taken. If they will not initiate the penalty there, they cannot go further. So generally, the National E-Assessment Center, after receiving the draft assessment, they can finalize, this is the final. Along with the penalty, they can issue. Or, if National E-Assessment Center find that they can provide an opportunity to assessee and solve this draft assessment order to the assessee and waited for their response. Okay. So when the opportunity provided to the assessee shall furnish response to it. He will tell, no, this is the addition you made, I am not agreeing because it is in my favor. This you have done without any fact. So you can make the response. After getting this response, then the National E-Assessment Center, in such cases, finalize the order, and any other case he can send to the assessment unit. So practically again he will go back to the assessment unit. So assessment unit again will be further verified. Friends, one point I am telling, any circumstances in the process they found that there is some technical unit requirement is there, other 4 units requirement is there, before finalization of the assessment order, they can also send. They can get the legal advice, they can get the data information, management information which prevails, certain information which they required, which is in the annual information report, so that they can take it. So they have to complete by taking into account all the information submitted by the other units. And after taking into account the response, they will make a revised assessment. Again, the assessment unit has no role. Only both the cases, they have to prepare the draft assessment order. Again, they will send to the National E-Assessment Center. National E-Assessment Center will send it to the review unit. Friends, as I told you, review unit has an important role to play, because review unit will see the addition made, whether the detailed explanation, sufficient justification given or not. The judicial pronouncements are available. If a tribunal or high court of Odisha is available, then whatever assessment taken place for the assessee in the Odisha, that whether that order has been taken or not into account. They cannot go beyond that. So this has to be verified. Then the final assessment will be completed. Assessment order will be served along with the penalty order will be served. Here, a lot of issues are there, whether the department infrastructure is sufficiently developed or to the equipped to that extent to accommodate this type of cross correspondence verification to go for the assessment. So friends, definitely it will take some time, because in 2009 when the return was filed, e-return was initiated, then it took 5-6 years to stabilize it. So definitely it will take some time, but this is the process has to be followed for the purpose. You see, this picture will show that there is no connection with the assessment units, 4 units. There is no connection with the regional assessment unit. Only all correspondence through the National E-Assessment Center. Where the National E-Assessment Center will be manned with that much of experienced persons and not only experienced persons, that much of efficient persons to handle all the cross correspondence, mails, etc. That is very important. The assessment completion depends upon that, because there is a time frame of assessment. 1 year from the end of the financial year in which return has been filed. So that is very important. Friends, these are after assessment completion, National E-Assessment Center will intimate this imposition of penalty, collection and recovery of the demand, rectification of mistake, giving effect of appellated order, submission of a remand report, and filing of a complaint before the court. Again, I am telling, once the assessment completed, the order will be sought to the assessee. At the same time, the order along with these items will be intimated to the jurisdictional assessing officer to take care. So that means the jurisdictional assessing officer responsibility is to take the initiation of the penalty proceeding, collect any tax demand, giving effect to the appellated order, any mistakes rectification submitted by both the parties, maybe assessing officer, maybe the assessee, that has to be made. Any appeal the assessee is going, that has to be handled by the jurisdictional assessing officer. So that means the books of accounts has to be kept by the jurisdictional assessing officer for going for the further section. So these are yes, I will take 5 minutes to cover it. Then it is much better. Actually, if there is a late, so I can also go little slow, so that to explain many of the items. So now question here is, when the penalty proceeding will be taken at different stages. As already I informed in the previous slide, if you go into deep, you will see the imposition of penalty, collection of a demand, recovery, etc. There. When we are going for the imposition of penalty, all the cases during the assessment stage, during the penalty stage, sufficient opportunity to be provided by the assessee, by the assessing officer to the assessee. That means National E-Assessment Center has to give natural justice to the assessee by giving sufficient opportunity to represent its case before the different authorities. So when they will go, what will happen? You just see the process what I discussed. During the process, if the assessing officer, the National E-Assessment Center issued the notice, but assessee could not respond. During the further information, it was asked, but assessee could not inform. Assessment processing, during the proceedings of the assessment, the penalty proceeding can be taken. The penalty proceeding can be taken at 2 stages during assessment when the assessee is not cooperating or not responding. The second is to be taken place after the assessment is completed. So both the cases, the penalty proceeding has to be initiated by the jurisdictional assessing officer. So now question is, any unit may send a recommendation to the National E-Assessment Center if it is considered necessary that the penalty proceeding has to be taken for non-compliance of the notice, direction or issued under this scheme, or for the initiation of any penalty under the chapter 21, wrongly I told 22, it is 21 of the Act against the assessee. So first, the intimation will be given by all the 4 units at what stage assessee could not respond and neglected in the compliance to the different provisions or notices or correspondences. So this will be given to the E-Assessment Center, National E-Assessment Center. National E-Assessment Center will go for the taking the penalty proceedings. Intimate to the jurisdictional assessing officer, go for the penalty. Any response to the show cause notice has been issued, mark the word show cause, because on the assessment proceeding, they have to complete the assessment, or if the draft assessment is there, while the draft assessment will be submitted to the assessee. So in that case, when the department feels that it is prejudicial to the interest of the assessee or further information required, the department can also ask the assessee to give the response. And while they are issuing the notices, they can say that a show cause has been issued why this demand could not be finalized, or why this addition could not be finalized, why this benefit could not be extended to you. So a show cause will be issued to the assessee, and assessee has to reply it within the permitted time. So that is very important. After receiving the response of the so-called notice, the National E-Assessment Center has the power to proceed without accepting or to drop the proceeding or the allegation which they are making in the assessment. So before finalization of the assessment order, the National E-Assessment Center has two roles. One is accept the response, not to accept the response. If you accept the response, then drop the proceedings and complete the assessment as per the information received from the assessee. So that is very important point at this stage, friends. I am telling there is a huge requirement for the department, for the assessee to take the help of the different consultants. Friends, I am just reiterating one point. Whenever you know that I was in service and as a assessee representative for 39 years, I took only the license of Bar Council as an advocate only from 5-6 months, got a lot of response. And I have the experience how to deal with the department and what difficulty we faced, and now I am finding what is the difficulty. We are also, what initiation we have to take to make it fruitful. The very important is sufficient professionals are not available, or the professionals, those are available, they are not giving proper advice. I will take two examples. One example is a client has come initially in the first month of my practice. He has 7-8 issues. Honorary client, I can say, because he come with a commitment that, sir, I will take you retainer, but I have some issues. And he has given 7 issues. I resolved the 7 issues. One issue I could not agree. I told what you have done is not correct. You do like this, so it will be correct. He is having a statutory auditor of my co-professional, and we have a discussion. The co-professional advised him not to go him. The reason was that, you see, at this stage, attempt of a manipulation is not possible. Again, I am telling very clearly, it is not so easy. Because your indirect tax e-filing system has been introduced, e-invoice is going to introduce, you cannot go escapement. There is a link between both. And whatever assessment so-called has been issued by the department during, so I have taken up 7 so-called notices with huge demands, ranging from 2 crores to 70 crores. All the cases, they have mentioned that information has been called from the income tax department portal, and this so-called notice has been issued. So, anyhow, we have a number of discussion also. He is discussing also now at present, but he could not take the proper advice. I told, okay, you go with your own arrangement, because I cannot advise you what you are doing. After 3 years, you will be scolding me. Definitely you will scold me. The second I am telling, a so-called notice has come recently from Service Tax Department, and one of my fellow colleagues, professional friends from this in CMA profession, came to me, sir, you just see this so-called notice, what to do? Can we go for Sabka Vishwas scheme? I found actual turnover is 12 lakhs. The return has been filed with income tax department showing the income 1.12 crores. Service tax has been paid on 12 lakhs. Department has taken the information from the income tax department, issued the so-called notice that your turnover is 1.2 crores and you have discharged service tax on 12 lakhs. I came to understand that what has happened, to take the loan, to liquidate the loan, the turnover has been inflated, and one of my friend, I can say professional friend, also signed the audit report, including the tax audit report that time, and submitted the return, everything complete. Now where do they have to go? Then I advise better to go for Sabka assessment scheme and give the tax. You cannot go escapement. You cannot show 2 returns. So you cannot show 2 information to 2 places. I am giving third one. You know, there is a protective assessment, there is one substantive assessment. What is protective assessment, what is substantive assessment? Many friends may not be aware. When the department finds that a particular source of income under which the lot of information is not available, and they could not decide on which hand it will be taxable, in the A's hand or B's hand. So in that case, they can take initiation of both the parties. It is in the indirect tax, it is in the direct tax. I came across one of my client who was under the protective assessment. I am giving the example because you should understand, for purpose of saying here is, just keep in mind, don't go for easy path always try to have sufficient records. Whatever information you produce to the department correctly. Friends, whatever your return has been processed under 143(1) because assessment could not take place, department after verification under the particular section after amendment in 2008, they will issue a notice for rectification of your return under 139(9). Once you submitted the response or submitted a revised return, CPC is not taking up. CPC is marking to the Judicial Assessing Officer for assessment. Don't do that. Once your assessment is referred to the Judicial Assessing Officer, you are handicapped. Produce all the documents, bank accounts. Somewhere you are doing mistake. So that's why you should be very careful. So in this protective assessment, what happens? The department has to initiate proceeding on both A and B. In the due course, to protect the revenue they have done, and it is a valid as per the decision of the Supreme Court. The issue here is a real estate company having taken a house from a landlord who is a government employee, and the landlord was paying the rent. They are good friends. The real estate company requires the money. The real estate company requested the landlord, please issue me a check of 40 lakhs. 3-4 times they have issued the check, 40 lakhs. Take one example. And this check has been issued by the landlord in name of the real estate company. Real estate company deposited the check, discounted the check in the bank, it's a bank, for 1 month or 2 months, and get the money after discount. And utilize it for business. On the date of presentation of check to the landlord bank, this person, the real estate person, deposited a cash in the bank account of the landlord. Okay, so by this, so bank paid to the real estate banker. So this type of transaction taken place 4 times, 1 crore 6 lakhs. During the assessment, the landlord account was under assessment. So when the information has been asked, landlord was not aware about this fact because he is a poor employee getting the salary, he do not have any other income. So now this has come under the assessment. So he has taken the plea that this is the transaction hasn't taken place. So how the department will believe? So both cases the assessment has been initiated. So one case is the protective assessment, one case is substantive assessment. Department has to receive the money from the substantive assessment or protective assessment. So this is a very important point which you have to keep in mind for the purpose. Let us proceed further. No personal appearance. So no personal appearance by the assessee. The appearance will be through the, you see, either I have to appear as an assessee or I have to appear through my authorized representative. Both cases, no appearance. Assessee and authorized representative shall be entitled to seek personal hearing to make his oral submission or present his case before the IT authority. Present, I am telling, I am finding one difficulty, I am expecting one difficulty. In the physical assessment, even also, judicial assessing officer is there, they are bound to do through the e-assessment system, but they are calling us, discussing, or for my interest, I am visiting them, explaining at least, you see, this is the addition which you are proposing, because of good relation. We are paying the tax very correctly. But this addition should not be made. These are the case laws we are producing. Sometimes the assessing officer feeling that, okay, actually they are wrong, the assessee is correct, okay, they are considering also. Now what will happen now? Because the show cause notice has been issued, because I wanted to have a personal hearing, because personal hearing will clarify everything. Submission will be made through the e-proceeding system. So I have to present somewhere to explain this is the fact. So it will be all will be done through the video conferring, and as per the circular has been issued, even under the scheme, the department has been authorized the principal commissioner to make a necessary infrastructure for the purpose of these personal hearing will be taken place through the video conferencing. Okay, actually, I think in the initiation has already been taken in the appellated forum, Nagpur Income Tax Appellated Tribunal and Pune. They have a connection with once in 3-4 years they tested it. It was very nice. The assessee is not required to go the assessment, appellated place in the video conferencing, they can complete everything. So it's a good system, no doubt about it, but only we have to see how it is going to be effective with the infrastructure. Against the order, we can go to the appellated forum. So that is very important. And just appellated forum will be dealt by the judicial assessing officer, and it will just continue as such. And this is no doubt about faceless assessment, and 24/7, any place, any time, you can submit the data and you can get the response. There is no requirement to be present only in the office, so that can be done. And a rule has been amended, and all the correspondence will be made through the electronic portal. These I am not discussing more. Electronic portal, emails, SMS, and other, no physical. So this will be given. These are the slides I will leave. You can see authenticated records. Again, I am telling. So in case of originator, the authentication has to be made by fixing the digital signature. If the assessing officer is using, it is a physical affixing the digital signature in accordance with the Section 3, subsection 2 of the Information Technology Act. In case of originator being the assessee, then in that case, electronic signature or electronic authentication technique has to be used. These are very clearly mentioned. Delivery of the records, again, as per the Section 13 of the Information Technology Act, what is the mode to be used for delivery, that is has been specified. And this will not discuss anymore. Personal appearance already we discussed, so these things will not discuss. Otherwise, I will ask some questions. Friends, for one information just I am giving, these are the facilities at present available in the e-proceeding. E-proceedings. E-proceeding is a electronic portal in the e-filing system of the ITBA functionality, which is installed in the departmental website, or it is a part of the departmental software development. So in that case, these are facilities are there. You see, all the responses, etc., has to be submitted through this only. These facilities, how to go step by step. One chapter in that insight, because it could not possible to submit the picture, it became voluminous, but only step by step has been given, that you can follow it for your understanding. All the cases, these are the cases, it is there. Around 30 items are there. And again I am telling, standard operating procedure for functioning of the e-proceeding, so far not issued by the department. Department may going to issue. And in that case, the certain steps may change. And again I am telling, the software upgradation, modifications may be taken place, by which this is also required to be modified. You can update it yourself with the department. So another very important is, no correspondence will be made by the department without allotment of the dean. And all correspondence will be, if any correspondence, communication made by the department to the assessee, or assessee is making cross correspondence, they have to refer the dean. Document identification number, which is compulsory from 1st October 2019. If any document has been issued without a computerized dean, it will be not treated as if delivered or as if received. So that is very important, which you have to keep in mind. And at present, the notification has been issued 147, 153A, 153C, 144. These assessments are not covered for the purpose, but they have given that, in addition to that, where the PAN is not available, where the ITR return was not filed, so where the VSAT is not available, in that case, the physical assessment has to be taken place. So with this, I am not taking more. With this, I am completing giving an overview of the idea about the faceless assessment and some practical difficulties. And if we can take. I am opening the house. If you have any specific question, I will try to explain, or my colleagues, those who are in the present also, they can explain you if you have any specific question on this. This is a new concept, no doubt about it. We have to update ourselves.